Today, I'm going to start by saying Bună ziua, Gamar Joba, hello. I am Georgiana Tekuc, a member of the DRBF Board of Directors Region 2, representing Europe, and the country representative for Romania. And together, Nina Taturova, the country representative for Georgia, will be our hosts for today's session. As you may know, DRBF Region 2 Europe has launched a webinar program. If it's Thursday, it's DRBF Day. And our webinar today is the fourth one, part of the DRBF Connection series. We will speak today about dispute boards and mediation, two ADR methods. And for your benefit, we will attempt to compare and contrast the two processes in our two countries. As our members well know, DRBF is publishing the Dispute Board Manual, a guide to best practices and procedures, which was last updated in 2019. The manual is intended to provide an authoritative explanation of the dispute board process and to serve as a reference guide for users of the process throughout the world. It also contains, in Chapter 3, a comparison between dispute boards and other ADR processes. And in comparing, it emphasizes the fact that dispute boards differ from other ADR processes by being the only process that enables parties to engage in both prevention and dispute resolution or adjudication. Our colleague, Nina Taturova, will tell you more about these two ADR methods, dispute boards and mediation. Nina is the head of the Legal Intelligence Solutions and the DRBF country representative for Georgia, as I mentioned earlier. She has a diverse expertise and experience of working on local and international construction projects of different nature, whether highways, sewage and water facilities, social infrastructure, hotels, residential and multifunctional building and rails. She is a founding member and management board member of the Georgian Association of Consulting Engineers, which is the FIDIC National Member of Association. She specializes in construction law and dispute resolution and deals with construction disputes and contracts. She is experienced in the use of FIDIC contracts and advises on drafting and negotiation construction contracts, claims, dispute avoidance, and dispute resolution in all forms, including dispute boards, arbitration, and litigation. Afterwards, Cremona will tell us about the dispute board procedures and mediation procedures, their scope, their role, and finality. Cremona Cotovela is a construction lawyer, mediator, and adjudicator with over 25-year experience. She's also trained in project management and public procurement. She is the main author of two FIDIC accredited models, FIDIC Basic and FIDIC in Public, and a friendly reviewer of the 2017 edition of the FIDIC Red and Silver books. Cremona is a founding partner of the first Romanian construction law firm, Tekuc Păltineanu, providing integrated advice on construction law and related public procurement, or EU and MDBs financing. She is currently the executive chair of the Public Contracts Committee of the Romanian Mediation Council and a FIDIC national listed adjudicator. Afterwards, Sophie will walk us through the selection and appointment requirements of mediators and dispute board members, as well as through the procedural documents. Sophie Tekamaladze is an FCIRB fellow and is an independent practitioner, mediator, arbitrator, dispute systems designer, and a consultant advising international organizations such like ADB, USAID, UNDP, GIZ, as well as Georgian public and private entities on various aspects of dispute resolution system and policy. Her practice includes arbitrating under the DRC and GIAC rules, serving as a chair of the DB in a dispute over a sewage system rehabilitation project under FIDIC Pink Book, and mediating commercial and community disputes in Georgia. Sophie presently chairs the Georgian Associations of Arbitrators and is a member of the governing board of the Mediators Association of Georgia. In 2020, she co-founded Resolve. We will then close with a quick review of the enforcement of the dispute decision and mediation agreement. And now I would give the floor to Nina. Welcome, Nina.
Thank you very much, Georgiana, for the very nice introduction for both for me and my colleagues. I will just very briefly give you the outline of what we are going to talk about today, as Georgiana already outlined it, but I will go in a little bit more depth. I will introduce you to the generalities of the both processes, and as Georgiana already kindly noted, the dispute board is the only process that enables parties to engage in the dispute prevention. As well as the dispute resolution. I think that's the main difference between the DBs and other forms of the ADR. So the DB can perform this function by giving to the parties the advisory opinions, recommendations, can engage in the periodical meetings with the parties on the sites and so on. The other main difference is that the DB is typically appointed at the start of the project and engaged until its completion. And as you may know, the other forms of the ADR, such as a mediation, arbitration, and other types of the ADR typically start when the formal dispute arises. The other difference is that the mediation is the regulated procedure. And for example, here in Georgia, the law on mediation was enacted in September of 2019. On the other hand, the DB is unregulated procedure. Unregulated, I mean by the law, unregulated. And the legal basis for forming the dispute board is the agreement between the parties. And as you may know, in the FIDIC standard form of contracts, for example, there is a separate clause on the DB, how to form it, how to appoint it, what are the requirements, what are the procedures, and so on. I would also like to mention that both forms, mediation and dispute boards, are quite popular in Georgia. As we mentioned during our webinar, a lot of dispute boards are appointed here in Georgia for the international construction projects. And the mediation is also very popular methods of resolving the disputes in Georgia. And even the courts are very keen on proposing to the parties this method to regulate their dispute. There is a lot of potential for both of these methods, ADR methods, and I'm very enthusiastic about it. So now I would like to give the floor to my colleagues, to Cremona first and to Sophie, to talk about a little bit more about the procedures of each form of this mediation and the DB, and also talk about the selection and appointment requirements, procedure documents, and then, as Georgiana mentioned, we will talk about the enforcement. So, Cremona, please, the floor is yours.
Thank you, Nina. I will start showing a little bit about the procedure and the background of the procedure. And we're starting with the fact that both are alternative dispute resolution methods. And of course, they have also applicable the certain principles that are common to all IDR procedures. First of all, the parties to the dispute are free to decide whether or not to have recourse to IDR. They decide themselves whether to organize the procedure based on the neutrality and impartiality of the third party. The third party that must also respect the principle of confidentiality, and most important, to have the trust of the parties. In our region, the mediation benefits from the interest shown by the European Union by way of consequence of its states members. European Union regulates the cross-border mediation in civil and commercial matters and defines it as being a structured process, however named or referred to, whereby two or more parties to a dispute attempt by themselves on a voluntary basis to reach an agreement on the settlement of their dispute with assistance of a mediator. The DB procedure is not as lucky as mediation to be backed up by the European Union, but it's a common and preferred procedure in construction contracts. The advantage of a dispute boards is that it's the only process that enables parties to engage in a dispute prevention as well as dispute resolution. And it's very important to remember, as Nina said, that a DB is considered as part of the project management and administration because it helps avoiding disputes and it solves them in a timely and cost-effective manner. Before talking about the scope of the mediation and DBs, we should start by saying that both IDR procedure have several versions. Mediation could be facilitative, evaluative, transformative, and there are also mixed forms known as Med-ARB or ARB-Med. The DBs could be a dispute review board, a dispute adjudication board, and perhaps we could add now the dispute avoidance and adjudication board as a distinct category and not only as a subspecies of the dispute adjudication board. Facilitative mediation is considered to be the traditional form of mediation where a specialized mediator helps parties to reach an agreement by becoming aware of the actual needs and the real issues in their disagreement, rather than considering their contractual or legal positions. The mediator will not provide an expert opinion on the pluses and minuses of the parties' cases. The purpose of facilitative mediation is to allow the parties to find a resolution to their conflict in a sustainable and self-determined way. Another form of mediation is evaluative mediation. In this form of mediation, whilst the scope is the same to reach an agreement, the mediator will concentrate on helping parties assess the legal merits and their arguments and make fair determinations. That way, it is possible for mediators to make recommendations and to express opinions. Also, it is very possible that the mediator is a lawyer specialized in the domain of the dispute. The third main form of mediation is the transformative mediation, which perhaps has the highest and hardest goal to fulfill because the mediator wants not only to solve a specific dispute, but to transform the parties and their relationship to make the parties understand and recognize each other's needs and interests. Regarding the DBs, the Dispute Review Board issues only non-binding recommendations, and the Dispute Adjudication Board issues binding decisions. In order to stress the importance of proactive role of DBs, as I said, the avoidance of dispute, we could add as a distinct category the Dispute Avoidance and Adjudication Board. Another important mention is that some contracts, as FIDI contracts, expressly provide that DAB or DAB proceedings shall not be deemed to be an arbitration, and the DAB and DAB members shall not act as arbitrators. The DB, if it's a standing DAB, is set up at the beginning of the contract, as Nina said, case in which the DBs may help to avoid disputes. If the dispute is not avoided, the DB will perform its second role, the reactive role, that of dispute solver. At the finality of the procedure, at the end of the mediation, the mediator will draft a report of the procedure. If the mediation was successful, meaning that the parties have reached an agreement, even a partial one, then the mediator could draft a mediation agreement containing the party settlement. Otherwise, the mediator will draft only the report of the procedure stating the failure of the mediation. In contrast with the mediation that usually deals with singular disputes, the standing DB will deal with an unknown numbers of aspects and issues that could become disputes. At this stage, the DB could offer oral or written opinion or recommendations. If and when the dispute is formalized, the DB must solve it by issuing a decision or a recommendation depending on the type of dispute board chosen. The decision or a recommendation must be transmitted to the parties within the time and with the observance of all contractual conditions stipulated by the main contract or and by the contract between the DB member and parties. Otherwise, the DB member will be in breach of its obligation. The norm is that the DB decision is binding for the parties. The mediation may be used in cases regarding rights and obligation on which the parties are free to decide themselves under the relevant applicable law. The DBs are used in construction of contracts, but lately other domains have started to use dispute boards as information and technology, defense industry, or insurance. Having given you the general framework of the procedures, I could tell you now about Romania. In Romania, we have the facilitative mediation, and it's regulated by law since 2006, and it's an activity of public interests. The legal definition of the mediation is that it's a way of resolving conflicts amicably with the help of a third party specialized as the mediator in conditions of neutrality, impartiality, confidentiality, and with the free consent of the parties. The Mediators bylaws states that the scope of the mediation is to restore dialogue, communication, and balance when where is a conflict between two or more natural or legal persons governed by public or private law, while preventing or resolving disputes, maintaining, relaunching, and reconstructing the collaboration between the parties in conflict. There is still resistance from the Romania public authorities to use mediation in public procurement work contract. The situation is expected to change, having in view that the national standard introduced by a government decision 3 years ago allows mediation as a method to reach an amicable settlement. In Romania, because it's an IDR method regulated by law, the mediation will take place following the rules and fulfilling the conditions, some of them mandatory for both users and mediators, whilst the DB will follow the procedure chosen by the parties in their contract. In Romania, the DBs were started to be used via FIDI contracts that were used in the public procurement contracts. But still now the public authority do not have a lot of trust in these disputes, and perhaps the main concern is the enforcement of the dispute board's decision. Sophie, now I give you the floor to you to tell us how the things are in Georgia.
Thank you, Cremona, for this introduction and guidance on the Romanian part. As for Georgia, so in Georgia, similarly, mediation is, as Nina already mentioned, it is a regulated procedure and a regulated profession. I'll focus for this moment on the procedure itself. So under the law, we also have a definition, and generally the definition is that mediation is a process where parties try to seek a settlement with the engagement of a mediator. In Georgia, we have two types of mediation, meaning it could be a court-annexed mediation or out-of-court private mediation. So court-annexed means when the dispute is referred to a mediator by a judge, and out-of-court means when parties on their own will, before they lodge a claim in the court, they themselves decide to engage a mediator. So in both cases, the law provides certain important guarantees for the mediation process. One is something that you've mentioned, Cremona, that's confidentiality. So whether it's court annexed or out of court, the law provides a framework of confidentiality, and there are, of course, certain exceptions, but in principle, it's a confidential process. Neither mediator, no parties can use information that has been disclosed in the process of mediation later in the court proceedings. An important feature is that under the law, when mediation is started, it stops the running of the limitation period. So that's also a comfort for the parties to start a mediation process. They already know that they will not be the mediation period will not be lapsed if they don't go to the court right away, but commence mediation proceedings first. Agreement to mediate under the law can be enforceable. I mean, the law says that it has to be an agreement which is either time-bound or there is a certain condition noted in the agreement to mediate. But if the agreement to mediate is properly drafted, then if the parties try to go to court or arbitration proceedings, the arbitrators or the courts, with the request of one of the parties, shall stop, dismiss for now, and then refer the parties to mediation if they have agreed on mediation beforehand. So that's another feature of the law. And the final and important one is the enforcement. I know we will talk about enforcement later in more details, so I will not stop here about enforcement. To echo what you have said, is that here in Georgia as well, primarily it's a facilitative model of mediation that is being used. The law does allow for the mediator to provide an opinion only when the parties have requested in written to and entitled the mediator to do so. So in principle, it's a facilitative model that is used in Georgia. As a short note that I would like to make about mediation, both you and Nina have mentioned that dispute boards are also used to avoid the disputes. I mean, it has this avoidance function and the role. And I know that mediation is primarily used after the dispute arises and formalizes, though I personally believe that it has a big potential to also, for the mediator, you know, whatever we call it, facilitator, mediator, so a skilled neutral, to be engaged in the dispute early on, even before there is a dispute escalates or formalizes. So I do believe that mediation has the room to be used, whatever we call it, facilitation, mediation, as a dispute prevention or avoidance or management kind of tool. And particularly with the, COVID affecting everyone, very often it is possible to predict, to foresee that there might be, the breach is coming. We will not be able to honor the contract. We're not there yet, but it's possible to foresee. So why not engage a skilled neutral to facilitate a negotiation? How can we adapt our rights and obligations, our duties, to something that we both can already predict? So as a problem-solving mechanism, I would say. So that's my personal view, but I'll stop here because I know we have to speak about other.
I agree with you about the preventing role of the mediation. And when I talked earlier about the bylaws, the Romanian mediation bylaws, I accentuated that fact that it's preventing disputes. Of course, we have to be very careful in what limits we act, because we'll be outside the law of the mediation. But there is no, it is not, there is a no obstacle to use or to develop the limits, to enlarge the limits within the mediation will be performed, because at the end it's about the parties' agreement. So, yes, I also believe that I believe that exists a preventing role of mediation and should be more, treated well from the legislation and by the mediators.
Thank you. And one more thing, by the way, about the procedure to add is, under the law, and I think that will be the case in most of the countries, the process of mediation includes private meetings of the parties. So it is possible to meet with the parties of the dispute separately in private meetings, what we call caucuses.
Yeah, under some certain conditions. Yes, I agree.
Yeah, at least in Georgia that is the case, and that very often helps the process move forward. And that would not be the case for the dispute board member to meet the parties separately. Yeah.
It will actually be forbidden, not recommended, but actually forbidden. Yes, a high indicator of potential conflict of interest there. I would like to go a little bit backwards, if I may. So far, it seems that we have very similar systems, obviously, both inspired by the EU framework, if you want. But you mentioned the statutory limitation. Can you tell me about the statutory limitation in terms of DB? Would interrupt the run of the statutory limitation, same like it does in mediation?
Yes. So first we have the law of mediation that allows the suspension of the course of the statutory limitation for 6 months from the start of mediation. Of course, if the parties can prove that mediation will have a success, that they are on the good path, it's possible to to win more time. And related to the dispute boards, we don't have, because it's not regulated, we don't have a specific legal provision, but our civil code allows the suspension of the statutory limitation when the contract between the parties provides for the for dispute resolution method before going to the arbitration or to the litigation to the courts. So yes, we have, it's a case, the common case of suspension of statutory limitation. The term is also 6 months, in which the parties benefit from this suspension of the prescription or the statutory limitation, as we call it.
Okay, thank you, Cremona. Nina, do you have anything to add about the two of them, or shall we proceed?
I'd like to add just one point regarding the limitation period in case of the dispute boards here in Georgia. It's not very straightforward matter here, because the relevant article from the Civil Code doesn't give the express answer to this question, and it may be argued both ways that, so for example, the referral to the dispute board stops the limitation period or not. That's very interesting, and depending on which part you present the client, you can argue both ways, I guess, because as far as I know, there is no relevant court decision in this regard or any other body of opinion. Maybe Sophie also knows something about it, and no, then yeah, here Nata also says that it really goes both ways. I have won the argument that the statute of limitation doesn't stop with a referral to the AB. Thank you, Nata. That's very interesting, because as I mentioned, it can go both ways.
Sure. So do you have anything else, or shall we proceed, Sophie?
I would like just to add a little bit about the formality of the procedures. Based on my experience, mediation is more relaxed process compared to the mediation, compared to the dispute boards, and it will be probably because in the dispute board, more legal parts, legal side of the case is discussed, and in mediation, depending on the mediator's approach, how he can lead the case, it is much more relaxed. So that's also another difference between these parts, between these two forms of the ADR. That's on the procedure and on the process itself. Now I think we can go to the other point, to the selection and appointment of the dispute boards and mediators. Also very interesting and hot topic.
Sure. Yes.
Cremona or Sophie, would you like to? Sophie?
Yeah. Thank you, Nina. So selection and appointment of mediators and dispute board members. Yeah, here, I mean, the way I see it, we can speak about when is the appointment be made, who can be, either mediator or the dispute board member and how. So this will be kind of the framework of discussion of this topic on my side. As you have mentioned, when talking about dispute board members, dispute board members, if it's a standing dispute board, most of the time, they are appointed and identified at the start when the contract is being concluded. So that's when they are being appointed. And if it's a standby, then it's later when the dispute arises or crystallizes at that moment. With mediators, as we've mentioned, most of the time mediators get engaged when the dispute arises. So in terms of timeline, that's the main difference, I would say, between the dispute board members and mediators. Now, who can be a mediator? That's probably one of the biggest differences. We mentioned that mediation is in most cases, as we saw both in cases of Romania and Georgia, is a regulated profession. In Georgia, mediators have to be members of the professional association, the Mediators Association of Georgia. So it's a legal entity of public law. And to become a member of the association, there need to be certain qualifications, the members have to prove certain certification that they have been trained properly, and then even take an assessment with the Mediators Association. So it's kind of a certified profession. If parties want to have a mediation as a process which is protected by the law in terms of confidentiality, enforceability, etc., it has to be a mediator, member of the association, so a certified mediator. In the case of dispute board members, it's totally up to the parties. So party autonomy has no limitations, no requirements of who can be, as long as parties agree and identify a member. That person can serve as a dispute board member. Obviously, I mean, the requirements of neutrality and independence apply in both cases. Under the law on mediation, that's something that is again guaranteed in the law, and the law actually requires for the mediators to make disclosures. So if there is any connection which does not raise to the level of self-recusal, the mediator has to disclose that to the parties, and only having kind of a agreement and green light from both parties, then proceed to manage the process. And in terms of appointment, I think that's how the appointment is being made. In both cases, the starting point, which is good, the starting point is parties' agreement. So if parties agree on the candidate of the mediator, then that person will be a mediator. If parties agree on the dispute board member, so party agreement is the starting point in both cases. Well, in case of mediation, if the parties have a mediation clause, but they don't manage to agree on the candidate, then the law provides that the Mediators Association can appoint a mediator. So if parties fail, the default mechanism steps in, and the Mediators Association will appoint a mediator, taking into account any requirements, qualification requirements that parties may have. In terms of appointment of the dispute board members, I can bring to the attention of our audience an interesting case law, actually a recent decision of the Court of First Instance in Georgia. It's a decision of 2019. And the issue there was that in the contract between the parties, they had identified 3 possible candidates for the dispute board member. So there was a short list of 3 candidates. Now, when the parties did not manage to agree on one out of those 3, they referred to the appointing authority. So under the contract, they had also identified an appointing authority which would appoint the mediator if the parties did not manage to agree. So when parties failed to agree, they referred to the appointing authority and asked the appointing authority to appoint a mediator, a dispute board member. Now, the issue there was that when the appointing authority actually called both parties to hear their views on the candidates. And so one of the parties said that none of those candidates suited them because all the candidates were of the nationality of another party. So the one of the parties requested the appointing authority to disregard the shortlist and appoint somebody outside of that shortlist. So the appointing authority did that. It probably deliberated and then appointed a person as a dispute board member outside of the shortlist given by the parties in their contract. So then the other party took this decision to the court to challenge this decision and ask the court to annul that decision. Interestingly, the court did actually annul the decision of the appointing authority, and the reasoning of the court was that the appointing authority's scope was limited by the shortlist, which was agreed by the parties, and so the appointing authority went beyond the scope of authority, and thereby it breached the agreement that the appointing authority had with the parties. It should have appointed, and it can only appoint a dispute board member out from the shortlist that the parties had agreed beforehand. So that's a recent case that I wanted to share in terms of the methods of appointment. I'll stop here and leave it to you, Cremona, to share the Romanian part.
Thank you, Sophie. Before that, I want to make a small remark about the cases. I think that the appointing authority will be in breach of the contract or outside the scope only if the agreement of the parties will provide that the appointing authority is obliged to name only from that list. This is the first one remark. And the second remark, when the parties do not agree upon the member and go to the appointing authority, that means they will accept the rules of that appointing authority, in my view. And maybe the appointing authority rules did not allow to choose a person from the short list. They are not obliged to, in the absence of the understanding between the appointing authority and the parties beforehand. What do you think?
As well.
Interesting. So I'm actually not sure if the appointing authority had specific rules on, on serving as an appointing authority. It's a good question. I'll check it. It's an interesting question.
For example, FIDIC that will appoint only from their lists, the president list. So this is an aspect that I think and again, should have been or had been
considered.
Yeah, as well. But if the short list of 3 was agreed by contract and communicated to the appointing authority in time, then perhaps the appointing authority was to choose one of the 3.
No.
It depends again of the rules and what the agreement was with the appointing authority, I guess.
And mainly the rules of the appointing entity.
Yes, yeah.
Okay, in what relates the appointment and selection of the mediators in Romania, we have a similar situation. And that means that the party could select the mediator only from the list of the authorized mediators who are registered in the panel of mediators managed by the Mediation Council, that is a public authority or central public authority that manage mediation in our country. And this panel of mediators is published in Romanian official journal. The parties could find out about the persons that are on this panel of mediators because this list is published on the courts. So it's easy for them to check. In the countries where the mediation is not regulated, the parties could choose the mediator from the list of the different bodies, organization, or association of mediators. For example, ICC rules of mediation show that the parties could come to them with several names, and ICC will choose one of them. If they do not have such a list, they will propose some qualities that they look for in those persons that will act as the mediators. If they don't have that, then ICC will take all the duty to select a person to act as mediator. In our country, in Romania, it is possible to have one mediator or to have more mediators in a single mediation cases. This because this is possible when both parties or all the parties come with their own mediator. But the law is very specific when it says that in this case, the mediators will not act as the representative of the parties. They will act, all of them, as the mediators, independent and impartial. And they will collaborate with within the mediators to establish the procedure. And usually they will select one mediator to conduct the meetings and the entire procedure of mediation. In what regard DBs, as I said, we use DBs via FIDI contracts. So the parties have the possibility to select and to apply the rules that FIDIC produce in what regards the selection and appointment of the DB members. Well, both DB members and mediators have similar restrictions in what regard the relations that they could have with the parties. They cannot be arbitrators or represent the parties in future or in past processes or litigation, arbitration, or to have act as a legal representative or give legal consultations. In what regard the professional requirements, also there are no specific requirements in law what regards the background, the professional background. Only it's needed to have a university degree. This fact caused a lot of discussion and sometimes has prevented the trust in mediation, because some of mediators and part of the public consider that mediators it's not necessary that mediators needs to have a specific qualification to act in a specific case of mediation. And the other part of the mediators and public consider that the mediator should reasonably know the domain in which they perform. And I agree with this second opinion. Soft skills are very important in mediation, but also to be able to help the parties to reach an agreement that can pass the control of legality. The first article of our mediation law states that the solution found by the parties with the help of mediator should be mutually convenient, efficient, and to represent a lasting solution. Also, there is an express requirement of the law that the mediation agreement, the agreement of the parties, if the mediation is successful, must not contain provision contrary to law and public order. Also, in the same direction, one of the pieces of information that is noted in the panel of mediators is the field of mediation in which the mediator specializes. In what regard the certification and the qualification of the mediators, the profession of mediator is exercised only by the person who has acquired the quality of authorized mediator under the condition of the law. The exercise of the profession of mediator by persons who have not acquired such authorization under the condition of this law constitutes a crime, and it's a sanction according to the criminal law. So we give a very big importance about to the authorization of the mediators. There are several conditions to fulfill when becoming a mediator. And so the person who wants to become a mediator must have the full capacity of to exercise his rights, must have, as I said, a university degree, must be medically fit for to perform this activity, and to have a good reputation, has not been definitively convicted of an offense likely to prejudice the prestige of the profession. Also, it's needed to graduate a specific training course for mediators, or to have a postgraduate program of master level in the field. But this program has to be accredited in according with the law and endorsed by the Mediation Council. And after all that, you will get to be authorized as a mediator by the Mediation Council. In what regards the DB members, it's the similar provision with the FIDIC contracts, nothing too different here. If the parties refer to a certain body as nominating authority, then the certification and qualification requirements are established by that authority. Also, we know that, for example, World Bank modified the condition of particular application. They used 2017 edition and developed this COPA, condition of particular application. And World Bank required that the DAB member has at least a bachelor degree in relevant disciplines such as law, engineering, construction management, or contract management, has at least 10 years of experience in contract administration or management and dispute resolution, out of which at least 5 years of experience as an arbitrator or adjudicator in construction-related disputes. And also requires that the future member has received formal training as an adjudicator from internationally recognized organizations. So more harsh rules in order to become a DAB member. In what regards the neutrality and impartiality, of course, these both are the two of the most important, the main important principles that regulates the mediation. Actually, we have 15 such main principles that regulates mediation. And we have the principle of professionalism, the autonomy, the freedom of procedure, and more,
so on.
and so on.
There's quite a long list. Well, before we getting through, because we are getting quite short of time, I would just like to emphasize a little bit. We're all familiar with the Halliburton versus Chubb case last year that created quite a bit of a havoc in arbitration. I would like to emphasize that the requirements of FIDIC and of the dispute board of DRBF laid out in the dispute board manual are so restrictive that I'm convinced that such a thing could not have happened in a dispute board procedure, appointing procedure. That DB member should have been disclosed and would have been aware from the very beginning that disclosure was to be made in full and mandatory. So I would be tempted now to reduce a little bit. I know you two might, and Nina might have had something to add to it, but as we are getting short of time, Nina, I would like to invite you to to tell us a bit more on the enforcement of the DB decision and of the mediator agreement, please.
Thank you, Georgiana. Just very briefly, because it's only 8 minutes left. The main concern with the dispute boards here in Georgia is the enforceability of the DB decisions. That's why sometimes they're more reluctant to use this kind of the ADR form, the dispute boards. And as Sophie already mentioned, the enforceability of the mediation agreement is already regulated by the law, and it's more convenient and gives the parties more guarantee that their agreement will be enforced. That's just the main outline, and maybe Sophie will add just 2 words because I know that she has interesting experience in this regard.
Yeah, thank you, Nina. Yeah, I agree with what you said about dispute boards. It's, yeah, that's the standing now. I mean, it's, I don't recall any court practice or any, yeah, that we don't have so far. As for the mediation, as I mentioned, the law provides for enforceability of the settlement agreements reached as a result of mediation, and that's the case both for court annexed and out of court, so private mediation. As long as the mediation is conducted by the mediator certified, then the settlement agreement can go to court, and the court will approve and may, you know, the enforcement order can be issued based on that. And the court practice is actually quite friendly, quite easy and flexible. Out-of-court mediation agreements have been enforced. Now, of course, there is the provision of the law, similar to Romania, that enforcement can be denied if it if the agreement is on something that cannot be enforced under the legislation of Georgia, or if it contradicts the public order of Georgia. So that is kind of the threshold or the limit. But in terms of the practice, I don't recall a case where that is the case. There have been cases where the agreement reached contained provisions that could not be subject to enforcement under the enforcement code. And in that case, what the judges would do is that they had called the parties in and discussed with them the terms of settlement, and then the parties decided whether they wanted to split and kind of have an agreement as a matter of contract on something that is not subject to enforcement, for example, apology, or some issues that by their nature cannot be subject to enforcement under the enforcement code, but leave the rest of it, which can be subject to enforcement, as a matter of agreement which would be subject to court confirmation, court order. So in that sense, enforcement is going in general smoothly, I would say. And I only add that because it's a new thing, Georgia is a signatory to the Singapore Convention. We have not ratified it yet, but the ratification procedures have been commenced internally, so it's on the way, and we expect that it will be ratified. Of course, the convention has not yet gained the acceptance worldwide, the similar as, for example, New York Convention or other conventions, but it's a fact worth noting. As the convention gains more acceptance, it will be important in the context of settlement agreements mediated by mediators, internationally, like reached internationally. So they potentially and in the future would be subject to enforcement in Georgia as well, in the regime of the Singapore Convention.
Thank you, Sophie. Mona, would you like to add something on?
First of all, to have a very quick something about the enforcement of the mediation agreements. The law of mediation says that if the mediation agreement that contains the agreement of the parties could be verified and attested by a lawyer or a notary, case in which this mediation agreement is changed from a deed under private signature to a deed with writ of execution, meaning that it could be executed and enforced anytime. In certain domains, as for example, ownership of the real estate, there are some conditions to fulfill the publicity conditions, but it's the same condition for any deed in that domain. There are also some cases in which this control cannot be made by a lawyer or notary, by the court, but this is what the court will do, will verify that the mediation agreement is observing the law, and if everything is okay, will issue an award that will contain the agreement of the parties. In what regards the DB's decision, of course, is the same old problem. Everybody worldwide it's confronted, but I had this opinion since I started to work with FIDE contracts. This is before 2000. And I think that the problem is to make the difference between the execution, the enforcement of the DAB decision, and the enforcement of the breach of the contract of not respected and don't give it effect to a DAB decision, irrespectively if that DAB decision is correct or not, or if it will be changed in arbitration. So this was the case because our law says that arbitration is possible, and arbitration is finished with a final award, with solving the disputes for good. And some authors says that, okay, if you go to with a binding but not final decision, you will not solve the conflict for good. But you don't go to that problem to arbitration. You go only with the breach of the obligation to respect and give effect immediately to that DAB decision that is binding but still not final. So I think it was discussed in the previous webinar about the enforcement of the DAB's decisions, and the trend is to agree with that, with our positions, that it is still enforceable. Of course, if the DAB decision is changed in arbitration, the parties will have the right to put in the situation before the execution of the DAB decision
to return
and to return the execution.
Well, I would say here, yes, because we're really short of time now, that we did discuss back in February. And in fact, our first webinar in the series was an introduction to dispute boards in Georgia, and we addressed together Nina, Nata, Gibradze, and Wana Shaimulescu the issue of the enforcement, and the records are available on the DRBF site. But in the nutshell, yes, dispute board is a contractual obligation. Both parties agreed to pursue the dispute board and to give effect to the decision immediately. So you go to arbitration to ask the parties to obey their contractual obligation to give effect to the decision.
Maybe now will be a better situation because the 2017 edition of FIDI contracts provide that the not execution of the DAB decision could be in certain condition a reason for termination of the contract. So this is a great weapon against not execution of against the parties that do not want to execute immediately the DAB decision.
I guess we shall see as soon as we start implementing the first 2017 edition in our countries. In the chat, someone was mentioning that the adjudication role of the dispute board shall apply the contract and will likely cause disagreement to one party more than the other one. Acting as a mediator, shall the DB help to find a halfway compromise solution which equally satisfies both parties? Well, in essence, I believe that the prevention is not actually a mediation role. It is a little bit different than the mediation, if you want, is more of helping, well, at the end of the day, it's going back to mediation, helping the parties to negotiate and to find the essence of the
mediation will most close to the prevention role of dispute boards will be the evaluative form of mediation and not the facilitative form of mediation.
Okay. So I hope that
I can give you an example regarding this question. I have seen the recent dispute board decision where the dispute board, there was a solo dispute member where he, in the preamble of his decision, he mentioned that he would like to make a compromise decision between the parties, not directly following the contract and the law. So I don't really agree with such approach because it's different kind of the ADR form, and maybe it should not be encouraged. I would say like this: if you would like to go to mediation, go to the mediation and follow that set of rules. If you are going to the dispute board members should not say that I am a mediator here.
Exactly, and shouldn't modify the contract. The dispute board does not have the capacity or the jurisdiction to modify the contract in any way. He should apply it, or they should apply it by the law. Thank you all very much. That's about all we had time for today. So before leaving you all, I would like to invite you to join us on the 13th of May to Renewables and Dispute Boards webinar. The recording of today will be available on the DRBF website in a couple of days at the most. So please be welcome to go back and look at various points that might have interested you, and you need to revisit and come back with any questions if you have any. And this being said, Madloba, Sophie and Nina, mulțumesc, Cremona, and thank you to all of you who have been here today with us. Goodbye.
Goodbye.
Thank you very much.
Goodbye.